Thanks, Les Corla. I'd like to speak to parts 11 and 12 of the bill, which fall under my remit, and both parts are subject to commencement orders as set out in section 2 of this bill. Part 11 sets out the amendments to the Social Welfare Consolidation Act 2005, which are required in order to maintain the status quo of the Common Travel Area. The purpose of these amendments is to maintain the current reciprocal arrangements for social insurance, which includes pensions and social assistance or means-tested schemes linked to residency rights, and child benefit between Ireland and the UK, including Northern Ireland. There are approximately 132,000 people in receipt of a UK state pension living in this country, and approximately 1,000 customers receiving child benefit payment from the UK for children residing in Ireland. There are 28,760 people residing in the UK who are in receipt of a state pension contributory from Ireland. 840 people residing in the UK are in receipt of a full-rate child benefit payment from my department, and these payments are in respect of 1,830 children, 95% of whom reside in Northern Ireland. A further 920 people residing in the UK are in receipt of child benefit supplement payments from my department in respect of 2,010 children, 97% of whom reside in Northern Ireland. And we want to ensure the continuation of these payments, and that's what we're doing with this legislation. Ireland and the United Kingdom share a long history of cooperation in social security matters, and the principle of reciprocity has been reinforced in our bilateral agreements and arrangements on social security between our two countries since 1924. And this is underpinned by the principle of equal treatment, so that Irish citizens enjoy the same benefits as UK citizens and vice versa. These rules are designed to protect people moving and working between each state and to minimise any disadvantage they might otherwise experience. From a social welfare perspective, maintenance of the status quo is of a critical importance to me and the Government in the event of a no-deal Brexit. And because of the unique nature of the Common Travel Area and the associated rights and privileges which it provides and will continue to provide for Irish and British citizens in each other's countries, it was agreed that Ireland and the United Kingdom would formalise the pre-existing Common Travel Area social protection arrangements in a legally binding agreement. Under the terms of that agreement, all existing arrangements with regard to recognition of and access to the social insurance entitlements will be maintained in both jurisdictions. And that means that the rights of Irish citizens living in Ireland to benefit from social insurance contributions made when working in the United Kingdom and to access social insurance payments if resident in the United Kingdom are protected, and vice versa. The agreement is subject to ratification processes in both Ireland and the United Kingdom, which are underway. And while I'm confident that the processes will be completed in both jurisdictions before the 29th of March, I need to be absolutely certain that the current arrangements can continue, even if all the necessary steps in that ratification process have not been completed by that date. And that's the overall purpose of the amendment in Part 11, which are required in the event of a no-deal Brexit. Section 76 provides for the purpose of Part 11, the Act of 2005, in the Social Welfare Consolidation Act of 2005. Section 77 provides for an amendment to Section 287 of the Social Welfare Consolidation Act of 2005 with regard to the continuation of a range of social welfare payments. And the amendments will provide for me, the Minister for Employment Affairs and Social Protection, to make an order with regard to the way in which arrangements under this section interact. Such arrangements may cover a number of issues, such as the recognition of contributions paid in countries such as the United Kingdom. It further provides that an arrangement under this section includes an agreement in certain circumstances which is intended to be binding, but where it has not yet become binding. And this will allow me, the Minister for Employment Affairs and Social Protection, to make an order to provide for the implementation of the Convention on Social Security between the Government of Ireland and the Government of the United Kingdom of Great Britain and Northern Ireland in the event that the ratification process is not completed by March the 29th. Las Corla, Section 78 amends Section 113A, which is an entitlement to invalidity pension in certain circumstances. 205, the recoupment of supplementary welfare allowance in certain circumstances, and Table 2 of Schedule 3, the treatment of payments equivalent to child benefit in a means test. And it also inserts a new Part 8A, which is entitlement to an island allowance. And these amendments insert specific references to the UK into the Act so that the same rules will be applied with regard to the treatment of the UK under these provisions when the United Kingdom is no longer covered by existing references to Member States in those provisions. As I've already said, I'm confident that the ratification process will be completed in both jurisdictions by March the 29th. However, I think it's prudent for us to proceed with Part 11 of this bill to ensure all eventualities are covered. I'm also responsible for Part 12 of the bill, which sets out a number of amendments to the protection of employees, Employers Insolvency Act 1984, which provides for the insolvency payment schemes. And the purpose of the scheme is to protect certain outstanding pay-related entitlements owed to employees in the event of the insolvency of their employer. The scheme covers employees who are in insurable employment in Ireland, and this includes employees who are employed in Ireland by an employer who becomes insolvent under the laws, regulations and administrative procedures of another member state. In the event of a no-deal Brexit, employers in a state of insolvency under the laws of the United Kingdom would not fall under the scope of the Act without the amendments set out in Part 12 of this legislation. Employees of those employers who are employed in Ireland would no longer be covered by the protection set out in the Act, notwithstanding that those employees are in insurable employment contributing to our social insurance fund. And it is therefore necessary to make the amendments to a number of sections of this Act to ensure that employees who are employed in Ireland and whose employer has been made insolvent under the laws of the United Kingdom will continue to receive the protection under the Act. And these are the amendments in Part 12, which I'll now talk about. Section 79 provides for the purpose of Part 12, the Act of 1984 is the Protection of Employees, Employers Insolvency Act 1984. Section 80 provides for the amendments to a number of the definitions in Section 1 of that 1994 Act. And when a claim is made under the insolvency payment schemes, it must be submitted by the relevant officer who has been appointed by a competent authority, and both of those terms are defined in Section 1.1 of the Act. Section 80 amends the definitions of competent authority and relevant officer to ensure that the administrators of employers which have been made insolvent under the laws of the United Kingdom can continue to submit applications on behalf of employees who are employed in Ireland. In addition, a definition of directive which is inserted to clarify the directive referred to is Directive 2008-94 EC of the European Parliament and of the Council of the 22nd of October 2008 on the protection of employees in the event of the insolvency of their employer. A definition of the United Kingdom has also been inserted to ensure that we are effectively treating the United Kingdom in the same way as it was when it was a member state, and to ensure that employees made insolvent in the United Kingdom will continue to fall under the scope of the Act. Section 1.3 of the 1984 Act sets out the circumstances in which an employer is deemed to be insolvent for the purposes of the Act, and the amendment to this section inserts a paragraph to include circumstances where the employer has been made insolvent under the laws of the United Kingdom. Section 81, Section 4.1 of the 1984 Act specifies the date on which an employer will be regarded as having become insolvent for the purposes of the scheme. And Section 81 amends this provision by inserting a new paragraph to include the date on which the employer is made insolvent under the laws of the United Kingdom. Section 82, the amendment of Section 7 of the Act of 1984. In Section 7 of the 1984 Act, it allows a claim to be made where an employer has become insolvent and has failed to pay contributions in accordance with the Occupational Pension Scheme or Personal Retirement Savings Account, a PRSA. Section 82 amends Section 7.3 of the 1984 Act to ensure that the amounts certified by an actuary or a person performing a similar task in relation to employers made insolvent in the UK and the employees are habitually employed in the state can be submitted for payment under the scheme. Section 83, transfers of personal data in relation to the employers insolvent in the United Kingdom, will insert a new Section 8A into the 1984 Act with regard to the transfer of personal data where an employer is insolvent in the United Kingdom. And in order to continue to make payments from the scheme to employees who are employed in Ireland, but the employer has been made insolvent under the laws of the United Kingdom, it is necessary for the personal data of those employees with UK administrators and insolvency practitioners. In this new Section 8A, it will give the Minister the powers to make regulations to share personal data with our UK administrators, and further provides that in sharing that data, the Minister will have regard to the important public interest and to ensure robust compliance with GDPR legislation. To conclude, Lascan Corla, in the economic uncertainties which may prevail in a no-deal scenario, I absolutely fundamentally believe it's vital that we continue the protection of the insolvency payment schemes to workers in Ireland, and that's why I'm introducing parts 12 of this bill. But like all my other colleagues who've spoken either today or yesterday with regard to this legislation, I sincerely hope that between now and the 29th of March that we will come to an agreement and there will be an orderly Brexit and that we'll never need to commence this legislation.
Minister,
Thank you.